morning and welcome to episode 70 of the Roadcast. Today I'm going to talk about the housing situation in Britain in 2024 with particular reference to the Great British Mortgage Swindle. For those of you that don't know, I was the co-producer of the groundbreaking documentary The Great British Mortgage Swindle, which came out almost 10 years ago now. And not surprisingly, given the facts of the matter, it's an issue that has not gone away, and you might argue it's even more pertinent in 2024 than it was almost a decade ago. In today's discourse, I'm going to talk about an actual situation that is unfolding with regard to a couple and their family. And I was speaking to the woman about it just yesterday. This is the situation. The family, of which there's a husband and wife and 3 children, 2 of whom I believe are grown up. And for the last 3 years they've been renting a home in a village in Nottinghamshire. They got notice to quit their rented accommodation maybe 2 or 3 months ago, and since that time the husband, who is in employment, well, both of them in fact, but largely through the husband, have applied for a loan with which to buy a house. Now, as we know, that application for a loan necessarily involves the individual granting a charge over the property as security for the alleged loan. If you've been watching my roadcasts over the last few months or so, you will know that I have put forward and demonstrated the facts surrounding what the banks fraudulently call loans. Essentially, it boils down to this: there is no lawful money, and all the money that is created into existence is largely created as debt, when in fact it is in reality credit, which is fraudulently misrepresented to the individuals as a loan. Nevertheless, when you enter into an agreement for a loan with which to buy a property, you necessarily will grant the bank a charge, in other words, a security over the property. And this is where the Great British Mortgage Swindle kicks in. And it's this that I wish to focus on today. And I suppose the question would be, what would you do if you were in this situation and you knew the facts of the matter as I'm going to outline today? So we'll just skip back to the situation. The family has been given notice to quit. They've been renting accommodation, and now they've decided that they will buy a house. And in order to do that, they have approached the bank for a loan with which to buy the house. This is the situation as it's unfolding right now in Nottingham. And I spoke with a lady in question yesterday about it, and I think it's very, very interesting, because what would you do in this situation? I'm going to begin by turning the clock back 40 years to when I was a student in the same city, Nottingham. At that time, rented accommodation for students and all manner of people across all levels of the societal construct was cheap. I can remember 3 friends and myself renting a large 6-bedroom house for £12 each a week. And okay, it didn't have central heating, it was a bit of a shithole, but it was alright, you know, for 12 quid a week. And if we spin forward 40 years, we're in this situation now where to rent a house, a 4-bedroom house, is going to cost you probably £1,000 a month, which is insane. And of course these days it's not so easy as it was back then. You weren't as mobile. You're not as mobile now as you were back then, because in those days, if we didn't like the accommodation, and we did this, we would simply do a moonlight flit. We would just leave the accommodation and find somewhere else. At that time, landlords were not seeking your ID, they were not seeking your bank details. There was nothing like that going on. So it was a relatively fluid market that was being operated, and from what I can remember, it pretty much worked. But this day and age, if you want to rent somewhere, you've got to provide your bank details, your ID, details of your employment status, etc., etc. So you can see from that how renting accommodation has become more of a closed market than it ever was previously. Anyway, to come back to the situation, one of the aspects of the Great British Mortgage Swindle that needs to be paid attention to is the role of the conveyancing solicitor. If you go back on my site, in 2015, I sued the conveyancing solicitor whose advice I was taking when I was entering into the loan agreement with the Bradford and Bingley. He was giving me his professional advice, right? And all I required at that time was the knowledge that the mortgage was lawful, the agreement that I was entering into was also lawful, and that every aspect of it was genuine. It was only some 16 years later that it became clear and apparent to me that I had fallen for the Great British Mortgage Swindle. A trap, a cunning trap that's been over 1,000 years in development, and originally came from the Jewish system known as the Shitar. I've explained this before. I'll provide a link for that particular point. But this is what you need to know. You look up the term mortgage, and you will see that effectively it stands as mort is death, and gage in this case is a promise, a pledge. So it's a promise to the death. What kind of fucking mind came up with that term? I'll leave you to ponder. Oh, there goes a grouse. A mortgage is a death or a dead pledge, a dead promise. Presumably it will only be extinguished upon the death of the individual. There's a building in Nottingham, a rather magnificent building, that was formerly, I believe, the Nottingham Bank. And at the top of that building you will see carved into the stone a monkey. And that monkey is known as the mortgage or mortgage monkey. And it's simply, you know, an acknowledgement in stone, if you like, of what a mortgage actually is. It's a monkey on your back, and it's going to be there until you die or until you discharge the blessed thing. Anyway, let's get back to this situation with the family. They decided, given the high price of renting, that it was most likely to be in their interest to take out a loan to buy a property rather than rent somewhere else. So they approached a lender, one of the licensed lenders, and employed the services of a well-known firm in Nottingham, a firm of solicitors. And I'll be coming on to them shortly. But remember this, I put out a meme last week stating that mankind will not be free until the last priest has been strangled with the entrails of the last lawyer. And what I'm going to illustrate today proves that point, I would argue. This is a situation. They've employed this firm of solicitors. Remember my point, no solicitor, judge, barrister, etc. knows anything about the law. What is the law? Do unto others as you would have them do unto you. That's it, in essence. By way of illustration, if we take that adage, that maxim, let's see how it works. If an individual is acting under the maxim, which he knows and understands to be correct, namely, he will treat other people as he would like to be treated himself. If he's able to cognise that and practice it, then he's acting lawfully. Anything in contradiction to that is unlawful, ipso facto. And what you have with the legal system is essentially a Talmudic construct whereby we have a series of deceptions and excuses that are all laid out in the language of legalese, which is a forked tongue language of deception. Basically, a system of a legal system which is not the same as lawful, a legal system that excuses the various trespasses and criminal acts of the aforementioned members of the judiciary, which includes barristers and solicitors, because remember, they are all members of the British accredited registry, namely the bar, and that is to whom they have their allegiance. I mean, you could argue on top of that they've sworn allegiances to various secret societies, often of a Freemasonic hue, which I've covered before, and I don't need to go into right now. Okay, so this is the situation. The family are in the process of the mother and father are in the process of negotiating a loan with which to buy a house. First point, there is no loan. No loan is going to take place. And, as you will see, they're about to enter in, or they may well be entering into a nudum pactum, which is a naked agreement or a naked contract in which one party to the agreement is offering nothing. In reality, is offering nothing and is therefore not performing its part of the agreement. So, this loan is dependent upon the husband's ability to earn the credits in the system. In other words, his salary. And at this point, it gets very, very interesting. First of all, they are paying this firm of solicitors, a well-known firm of solicitors in Nottingham. They are paying them for their professional advice and their knowledge of the law in order to make sure that everything is as it appears to be. That a loan is going to take place, that the contract is lawful, and that every aspect of it is above board. However, as we know, the Great British Mortgage Swindle is dependent entirely upon the actions of the conveyancing solicitor, whose job it is to procure for and on behalf of the bank the security, namely the deed of mortgage, which in and of itself is a valuable commodity, if you like. In other words, it can be deposited at the bank and is deposited at the bank, well, by the licensed lender. Remember, there are no banks because they're not lending any money. And this is the catch. Here is the rub. Firstly, even under the purported legal system, okay, there is a lawful requirement under sections 1 and 2 of the Law of Property Miscellaneous Provisions Act 1989. So this statute has been in place for 35 years. 35 years on, and we see that all the conveyancing solicitors, all those companies who are assisting people with loans, with these mortgages, if you like, continue to flout the law. What do I mean by that? Well, let's look at this current example. Because the husband is in his early 50s and his wife is not in employment as such, the responsibility or the liability for the loan is almost entirely on the shoulders of the man, of the husband. Now here's the rub. The 1989 Law of Property Miscellaneous Provisions Act states quite clearly that there must be a valid deed and that there must be an agreement or a contract. Any disposition of an interest in land, which includes a mortgage, obviously, has to be in writing and the agreement has to be signed by both parties to that contract. That means that the duly appointed officer or agent of the bank has to sign for and on behalf of the bank / licensed lender, along with the individual who is entering the agreement. This firm of solicitors do not appear to be following the law. And you may say, well, that's just how it's done. That is the common practice. They don't fucking know the law. They don't even know the statutory law of mortgages. We are living in a fucking realm of complete and utter idiocy. But let's just focus on this situation right now as it's unfolding. Right, the first thing is this issue about a valid deed of mortgage. What the solicitors are encouraging their clients, okay, whose advice they are reliant upon, to do is to sign a mortgage deed over a property which they do not own. They also are asking the individuals to sign the mortgage deed but not date it. The instruction is sign the mortgage deed but not date it. In other words, they expect them to return an incomplete mortgage deed to the firm of solicitors, who are, remember, procuring this valuable instrument for and on behalf of the licensed lender, the bank. Why, you might ask, is there an instruction not to date the mortgage deed? And is it important? The solicitors will say 99.999% of the time, oh, don't worry about that, it's just how it's done, it's just the common practice. But remember, the appeal to common practice is a logical fallacy. Just because something is commonly done does not mean to say that it is lawful. The reason they are asking them not to date the deed of mortgage is this: because they, at some level, they know you cannot put a charge over a property that is not yours. The Supreme Court confirmed this back in 2014. It was a case involving Southern Pacific. I'll link you to it, but in that it was quite clearly stated that this practice of procuring mortgage deeds by solicitors from individuals over properties that they are manifestly not the owners of was destined to kick them up the arse, if you like. I mean, I'm summarising here. But the warning by Lady Justice Hale was that the common solicitor, the conveyancing solicitor, had to be very, very careful, because this case demonstrated beyond a shadow of a doubt the logical point that you cannot grant a charge over a property that you are not the owner of. It breaks down completely because it's nonsensical. It's completely illogical. The solicitor will say, oh, well, there's no need to date it. You don't need to date it. We'll fill that in at a later point. Now, if that was truly the case, ask yourself this question: would the land registry accept a deed, a mortgage deed, that was undated? What's going on is this, and this is but one element in a whole series of deceptions that are taking place with regard to the Great British Mortgage Swindle. Not just the Great British Mortgage Swindle, but any mortgage. And it's this: when the bank releases the funds, which are merely the credits, if you like, the figures on a computer screen, with which the individual can purchase the house, then and only then can the date be put on the mortgage deed. But even at that point, you could argue, well, the individual's still not the actual owner of the house. You remember, possession is 9/10 of the law. So the switcheroo, the bait and switch, if you like, is essentially this: you go into the meeting with the licensed broker. The bait is simply the prospect of purchasing a house. So you're going in as the creditor of the licensed broker. You're the creditor behind the entire transaction. You go into that meeting and they've switched it round. Somehow you've become the debtor to the licensed broker, even though there is never any evidence of a loan. No loan takes place. The licensed broker, the bank, is not lending you a penny, anything from its own coffers. So that's the first point. The advice, the negligent advice from the conveyancing solicitor is that the individual signs but does not date a charge, okay, a charging instrument, the mortgage deed, over a property that they do not own. That is unlawful. You can't get around that. The other important aspect of this multi-level swindle concerning the conveyancing solicitors is this. The 1989 Law of Property Miscellaneous Provisions Act states quite clearly, as I said, that any agreement for the sale or disposition of an interest in land, which a mortgage is manifestly of, has to be agreed upon by way of a signed contract, a contract that has to be signed by all parties, including the duly appointed officer of the licensed lender. However, I have never seen such a document, even though it's a statutory requirement. You might ask yourself the question, why is that the case? Why does no officer of the bank ever sign a contract with the individual who's taking out the loan, namely the mortgagor? I would argue because it's a criminal racket, and they've been instructed not to put their names to this, because the ultimate fraud is that nothing is being loaned. That is the deception. So I've stated to this woman that given the fact she's employing the services of these conveyancing solicitors, she needs to challenge them. And it would only take an email, right, asking those two questions. Number one, is it lawful for me to sign a mortgage deed over a property that I do not own? Because according to the 2014 Supreme Court case, that is exactly illegal. Secondly, the question would be, according to the 1989 Law of Property Act, it is a statutory, a legal requirement for all parties to the mortgage agreement to sign a contract. Where is it? I mean, the third question that would follow on from that, which I would ask, is this. So you're telling me, right, you're speaking to this, the conversation might go something like this, or it might be in writing, to the conveyancing solicitor. So you're instructing me, and you're providing me with your legal assurance that everything about this arrangement for a loan is completely lawful. And the solicitor is likely to say yes. Don't worry about the dating of the mortgage deed, that's just how it's done, it's common practice. They might even try and falsely claim that there is no requirement for a contract between the parties, even though it's stated as a statute that there is a requirement, a lawful requirement. And of course there are a number of cases in which, I mean, involving banks, I hasten to add, in which mortgages have been declared null and void on the basis that there was no contract, no signed agreement between the parties. You see, this is the dilemma. What would you do in this situation? If you've got the information that I've just given you, right, and if you've just got a basic understanding of it, what would you do? You've got a family, you need somewhere to live. What would you do? It's been explained to you about the statutory requirements for a contract and a valid deed of mortgage. The solicitor who you're employing has advised you that everything is legal and there's nothing out of order, and it's all set up to go. And of course, the solicitor, you know, I mean, another question would be, can you reassure me, right? I'd like your legal advice on whether I am actually going to be receiving a loan from the bank, or whether the entire credit creation has been brought into existence by my signature and my promise to pay over the duration of the mortgage, the dead pledge or death pledge of 25 years. And in this case, there's another interesting aspect to that, which I'm going to come into. So they're paying these solicitors very handsomely, I would argue. First of all, one of the partners of the firm is charging a fee of £365 an hour. That's £1 a day over the course of a year. He thinks that is what his advice is worth. I mean, it gets very interesting when you see these figures. There was also something like 100, and I've seen this, and I've seen the correspondence. So I'm not just talking out my arse here. There are various charges for the services of the solicitors. And they're high, they're very considerable. But you won't be surprised, because we know that solicitors are in the business of bleeding people of their monies, essentially. There was also a charge of £155 for what they stated was a land registry search. I mean, fucking hell. You can go online, you can go to the land registry, you can do all the conveyancing yourself, incidentally. I mean, they don't like it because it's a closed shop, and you will be encouraged to take on the services of a conveyancing solicitor. But you can go online, and the land registry has got on their website, as the assistance you may require, you can do a search for any property and find out what its status is. You know, whether there's a mortgage over the property, whether it's free or clear, whether it's low deal title, freehold, etc., etc. And it's not difficult to do. You could probably accomplish that in half an hour or so. And yet this firm of solicitors, these conveyancing solicitors, are charging their client £155 to do that search. I mean, there are other anomalies in terms of their charges. But let's just get back to this point. The question is, what would you do in that situation? The dilemma, of course, is that the housing market is currently grossly overinflated, to the detriment of the indigenous, to the detriment of everybody, but particularly the indigenous peoples, the natives of the Isles of Britain. Okay, so the dilemma is, do I rent or do I buy via a loan? This is the situation. So I've said to this woman to do just that. Remember, she's paying, or her and her husband are paying thousands of pounds for the professional advice of this conveyancing firm. In other words, they are seeking to buy a house, and in order to do that, they wish to enter into a lawful agreement for a loan with which to buy the house. The solicitor's role is to make sure that everything is above board and is hand in hand with all the requirements. And I'm talking specifically, we're just talking here specifically the statutory requirements of the so-called law of mortgages. As an interesting aside, from what I noticed, it's largely women that are running this. So the question would be, is it lawful for me to sign a mortgage deed, a deed of mortgage over a property that I do not own yet? Question 2, is it lawful for me to sign that deed and not date it? And if it's a requirement that I do not date it, could you please explain why? And the next question is this: could you please confirm that there is no requirement for me and my husband and I to sign a contract with an officer, a duly appointed officer of the bank? In other words, where is the agreement for the mortgage charge? So those are three very simple questions to ask the conveyancing solicitor, and they can be done face to face, or they could be put in writing. I would suggest putting it in writing and emailing it to the company, copying the CEO of the solicitor's firm, but email it to the actual conveyancing solicitor. Both of whom are being rewarded handsomely for their services in this game. Oh, and another question, of course, which you could ask is, could you please confirm that you are representing me? You are acting in my interests and my interests only. The answer to that question would be very interesting, because it soon becomes apparent, as was the case in my situation some 30 years ago, that the solicitor, the conveyancing solicitor, is simultaneously receiving a fee from the licensed credit broker, the bank, at the same time as he is purporting to be in your employ and providing you with the legal advice that you require, not being an expert in matters of the law, to satisfy you that everything about this agreement is all above board, is legal, is lawful, whichever way you wish to construe it. And when they get back to say, well, yes, this is how it's done. This is the common practice. This is how we do it. We will advise you that your mortgage is lawful and it's all above board and everything is as it should be. I hope you can see that at this point there is a massive liability that has now landed on the shoulders of the individual conveyancing solicitor and her company. Invariably, they will say, it's all fine, go ahead. Now, at that point, it would be entirely reasonable to write back to the solicitor and say, well, look, you've said that it is common practice to do this, to sign but not date the deed of mortgage before we are the owners of the property. But in 2014, the Supreme Court made this ruling that states quite clearly that you cannot do that. It's illegal, never mind lawful, impossibility to grant a charge to a licensed lender over a property that is not yours. Secondly, when they get back and say there is no requirement for a contract signed by all parties to the agreement. Now, at that point, you've got them by the balls, because you could simply reply, it states in the Law of Property Act 1989 that there has to be a signed agreement in place by all parties. And then you would finish it off by saying, could you, in the light of this information, I'm asking you once again, could you please confirm that the mortgage the agreement is completely lawful, that it's legal? And then fourthly, it would probably be a good idea to say, as my legal representative in this matter, who I expect to be doing due diligence and who I am paying handsomely for her legal advice, could you please confirm that I will be in receipt of a loan from the bank, from the licensed credit broker, and that my signature on the deed of mortgage is not that which is actually creating the credit with which to purchase the property. Because remember, we are operating in a credit system. That credit is stolen and switched round as a loan, and it's exactly what's going on here. With regard to the competence, the legal advice that is being proffered by this firm of solicitors, I'm not going to name them, but I'll give you a clue as to who they are. Kiss Me Quickly, Hardy. That's the name. You could say there's a certain pillar in Trafalgar Square that features their name. There's another aspect to this which we would do well to look into, because it illustrates exactly what I've been saying about how none of the so-called legal professions know anything about the law. And it's this, it's very interesting. The wife is not going to be named on the mortgage, however, she's putting up some of the monies for the necessary deposit. These solicitors, the conveyancing solicitors, have drawn up a document for her to sign in which she basically signs away her rights to a 50% share in the equity of the house, even though at law it's been long established that a spouse is entitled to just that. So what kind of a solicitor would draw up such a demonstrably void instrument for her to sign? Secondly, and this is even more incredible to me, because the husband is in his 50s, they have, I mean, this is as hilarious as it is daft. The solicitors have drawn up a document for him to sign, a declaration, if you like, stating that he will continue working into his 70s because of the nature of the mortgage agreement, which presumably lasts for 25 years. It boggles the mind. How on earth a solicitor who is purportedly knowledgeable in matters of the law can actually draw up two such bogus documents? I mean, I'm presuming this is for insurance purposes, because the bank does take out insurance on these purported loans, but it's just a fucking racket. Can you imagine signing a document stating that you're prepared to work into your 70s in order to continue making the payments on this this mortgage agreement? That, in and of itself, is a fucking nullity. It's completely unenforceable, and it has no basis in law. Just as the document purporting for the wife to sign away her right to the equitable interest in the house is completely unlawful. And yet these fucking solicitors, these negligent, fraudulent ponces who were being paid for their legal advice, for their knowledge of the law, are drawing up what I would argue, and what many would see immediately, are nothing but complete nullities. Nullities. Absolutely fucking worthless. And of course, you might argue, quite rightly, that all this is done at the behest of the banks. And it really is these financial overlords, these money masters, these deceivers, who are actually pulling the strings at every level. How much longer it's going to last, I don't know. I think the whole thing is destined to collapse because it's riddled with fraud at every level. The entire operation, just the Great British Mortgage Swindle, is a house of cards. Effectively, what's going on and what is being traded are these worthless pieces of paper, these nullities, these void instruments that have been illegally procured for and on behalf of the banks by the negligent conveyancing solicitors. Those conveyancing solicitors know fuck all about the law, and that's why I stated that mankind will not be free until the last priest has been strangled with the entrails of the last solicitor. I mean, it's a complete racket, and I'm smiling because I do appreciate the sleight of hand that's taken place. I mean, it's all completely unlawful, but in a way you could argue that it is genius. I mean, evil genius. So if the conveyancing solicitors answers in the affirmative, yes, all of this is common practice. This is exactly how it should be. You can sign the mortgage deed over a property that you don't own, and you don't have to date it, because we'll fill that in at a later point, namely when the credits come through. Secondly, the 1989 Law of Property Act miscellaneous provisions does not apply in this situation. It doesn't apply to mortgages, which is wrong. It's a lie. There have been high court cases, Sahib versus Sahib, I think, is the one, which demonstrably proves that this is the case. And they'll say, oh, you don't need to sign an agreement, you don't need to sign a contract. This is common practice. So we'll flout the 1989 Act. We'll just completely ignore it. We'll pretend it doesn't apply. And then, as to the issue of a loan, if they reply that yes, the bank will be making you a loan of monies from its own coffers in order for you to purchase the house, then that is another egregious lie. In other words, as I stated at the start of this, none of these lawyers know anything about the law, let alone the monetary mechanics involved in loans, not just mortgages or loans for the purchase of property, but in loans of all natures. It would be hilarious if it wasn't so tragic. If they get back to you and they affirm, in this situation, say that the conveyancing solicitor returns, gives her answer to the question and merely states, yeah, don't worry about it, it's common practice, this is how it's done, we're advising you to go ahead with it. Oh, and by the way, here's a bill for a few more £100 that you owe us for our advice. So this is the dilemma. Do you take the advice of the solicitors at face value? What would you do? Are you going to listen to someone like me walking through the woods, the co-producer of the Great British Mortgage Swindle, someone who has been at the front end of this scam for a number of years now? Are you going to listen to somebody like me, or are you going to take the advice of the woman who's acting as the conveyancing solicitor, to whom you are paying thousands of pounds. You're paying thousands of pounds for her expertise and knowledge in these matters. There's also the issue about her conflict of interest. In other words, about the fact that she's been simultaneously paid by the bank. She's on a kickback, if you like, or a reward for her services in procuring the deed of mortgage. Remember, this deed of mortgage in and of itself is a very, very valuable instrument, a security. It is this, with the signature on it of the individual, that creates the credit in the financial system. So if you were to accept at face value the advice of the conveyancing solicitor, and you go along with it to the point where you move the family into the house, what would you do next? You've got evidence, material evidence, that the conveyancing solicitor has acted negligently, and that you have, at the behest of the conveyancing solicitor, entered into an unlawful agreement. In other words, that conveyancing solicitor has falsely advised you, negligently advised you, to enter into what is manifestly a criminal racketeering programme, namely the Great British Mortgage Swindle. There'll be more on this as it unfolds, but I'll be very interested to hear comments from those who have got their heads completely around this and understand the exact gist of what I'm getting at here as to what should occur. That's the question. Right, from a rather overcast Sherwood Forest on a gloomy day in December, Friday the 13th of December, I'll end it there for today. But before I go, I would like to extend a heartfelt thank you to each and every one of those who has liked, shared and made a donation via the Buy Me a Coffee button, as a way of showing their appreciation for these discourses and the essays that I pump out at roguemail.org and at Substack. It is truly appreciated. If you're able and feeling suitably appreciative, please buy me a few coffees via the Buy Me a Coffee button, which is linked below. Also, if you do that, please leave a comment. I will get back to you. Let's watch this space and let's see what happens, because, you know, this is a real life situation that is unfolding right now. And it is an interesting dilemma, because I've tried to explain it to her in the terms that I've laid out today. But, you know, invariably, the levels of mind control go so deep into all of us that it appears that I'm just a bloke in the woods who's spouting on about the illegality, the unlawfulness of all of this, whereas some woman who's wearing a smart two-piece suit and pouncing about in a solicitor's office is likely to be given more credence. But that's the dilemma. Do you accept that the conveyancing solicitor has your interests at heart? Do you accept that the conveyancing solicitor knows what she's talking about when she tells you that this is how it's done, this is the common practice? Do you accept that as being valid purely because she's got some initials after her name? That's the dilemma. Thank you for watching what has been episode 70 of the Roadcast. Whoever you may be, wherever you might be, I would like to wish you all a splendid day. Until the next time, cheers.